Hi, good morning and good afternoon, everyone. We'll just give it another minute for more people to jump in. Feel free as well, pretty early on, let us know where you're tuning in from, what your business is, what you do, and what you're looking to get out of this webinar if you have any specific questions off the bat, because we will be doing a Q&A throughout and at the end as well. So it'd be great to hear what everyone's keen to learn and to listen to. Right. Let's get started. Okay, so hello again, hello everyone, and welcome. My name is Connor Spencer. I am the team lead of our Legal and Accounting Solutions team, and I'll be your host today. Thanks first of all for joining us on our webinar on Legal and a Tax Guide to Staying Compliant in 2025. And as I sort of mentioned there, if you do have any further questions on LawPath throughout or this topic, or you do actually want to understand a bit more of how we can help your business, feel free to connect with me through the chat or respond to my email later. But if you are discovering us for the first time, our mission at LawPath, simply put, is to empower businesses to succeed by making your complex legal and tax matters simple, accessible, and manageable. Our office is now teaming with lawyers and accountants. They all have decades of experience working with small businesses like yours, so we understand perfectly well the day-to-day, the year-to-year challenges, the costs, and most importantly, the answers to your questions that business owners are faced with when either ensuring their business is compliant or just want those hot tips to run your business better than your competitors. We're an Australian online legal and accounting service, and we provide unlimited access to our 500 document library. We can register your company, register your trademarks. We provide unlimited consultations with our legal and accounting team. And where you may require more bespoke work, we do also offer tailored contract drafting and tax work as well. And so all this and more, accumulating over $500 million saved for over 500,000 businesses over the last 10 years. But don't just hear it from me. I'll be sharing shortly a couple of useful links in the chat, and one of those will be our client video testimonials. But if you don't hit the link, you can still find it on our website and our YouTube page. We're excited. He's not in just yet, I think, but we're excited to have both Damon Murdoch, our principal lawyer, and Timothy Quinn, our head of tax and accounting at LawPath, sharing their expertise. If you're not familiar with Damon, he is LawPath's principal lawyer. If anyone wants to view our Meet the Lawyers page on our website, it's one of the links I'll share. You can see our lawyers who deal regularly with our legal advice plan clients. You'll see, for example, Damon has a 5 out of 5 star rating of over 300 reviews. A bit of background on him. In a nutshell, Damon is a one size fit. Always regularly assists and advises on startups with and small businesses, all facets of business commercial law, from contract drafting, negotiation contracts, assisting with investors, employment law, health and safety policies, and he has advice on capital raising transactions valued in excess of 600 million. And acted on behalf of over 2,000 startups. And we're also joined by Tim Quinn. So he's a qualified accountant with over 17, 18 years of experience in tax and business advisory at all stages of business. You can see there some of the things he's an expert in. But overall, has an extensive experience supporting entrepreneurial clients meet their tax obligations and advising on how making the tax system work best for them and their businesses. So this includes early stage investment incentives, government grants, tax offsets, employee share schemes, restructuring, and you've got some experience, I believe, as well, Tim, in international expansion and exit strategy planning. So the slides will be sent out later today in an email, but do feel free to make notes on what Tim and Damon mentioned throughout, and obviously ask your questions throughout the webinars. We will do a Q&A midway through the webinar after Tim's content, as he has to hop off, but we'll do a final one at the end. So do hang around to get your questions answered and also hear other people's questions as well. But we'll jump in. I'll hand things over to you, Tim. Oh,
Thanks,
sorry.
Connor.
Just a quick thing on what we actually will be covering. The topics, well, there's obviously a lot more subtopics involved here, but broadly speaking, we're going to cut across the tax and accounting planning, legal planning, reflecting on your business structure, and the importance of reviewing your business contracts. So without further ado, I'll hand over to you, Tim. Thanks.
Thanks very much, Connor. Much appreciated. And thanks to everyone for joining in on at least my first webinar of the year. So if I'm a bit rusty, please forgive me. I've had a long and enjoyable Christmas break, but let's see how we can help you out. A couple of questions have already come through. I'll make sure to cover off a couple of those topics for those of you who have asked. What are we talking about here? Let's start off with business structures. If we imagine your business life cycle, we're going to start off with the early days. Let's get you set up in a way that is going to make you most tax effective going forward. If you're already in operation using a different structure, that is no problem at all. You can always change. There's lots of tax concessions available to you to change to new structures as you go. So if you're not set up like this at the moment, don't let it stress you out. The ideal structure, what I like to call basically the golden solution to any of your tax issues, is this idea of the dual company structure. So some legal benefits that Damon will certainly talk to you in more detail. I'll talk to you about some of the tax benefits and some of the capital raising benefits of having this dual structure. When we're talking about a dual structure, I mean basically a holding company, and then below it, a different operating company for all of your major operating businesses. And hi, Damon, thanks for the wave. Why do you bother with this? Is it to create more work for the accountants? No, it's not. That is a helpful side effect, of course, for my business. The reason why you would separate into holding and operating companies is scalability. That's the first and most important thing from my perspective as a tax accountant. If you are out there looking to set up your business to attract investment in the future, you do not want to go and update 5 different operating company asset records every time you issue new shares. Every time you get money coming into your business, you don't want to be doing that. You want to change it at one level, change it at your holding company level, and everything else is automatically updated there. What happens when you take money in as an investee, as a company that's seeking external funds? Holding the money in this holding company structure, as opposed to in all of the operating companies that are actually doing something, really protects you from lawsuits to a significant extent. If you imagine you're operating in some industries where lawsuits are fraught, which is many different areas these days, if you are attacked from a legal perspective on those operating companies, and if you hold all the money that you've raised in a separate company, you've got a degree of protection. So that's a huge opportunity. I said, is this sort of structure led by accountants wanting to generate new work? Not necessarily. You can do what's called a tax consolidation, that you can basically treat yourself as one tax-paying entity. So it actually can include no additional work for you. It's a very nice structure, which you should definitely consider. It's easy once you've got this flexible structure to add new operating companies, and that way you're ring fencing you from any of them necessarily infecting. You know, if one of them falls off the perch, you cut off the branch. You don't have to cut down the whole tree. So we love that flexibility from a business structure perspective. Thanks, Connor. Now, I sort of already explained the dual company structure. What's this cheeky little fella at the top that's popped in, the family trust? Once you've got that holding company and that trading company, you might think that you're done from a structuring perspective. But this family trust owning the shares in that holding company, rather than you and your partner or you and your business partners, holding the shares in the holding company through a family trust is going to be incredibly beneficial to you. And I'll show you why on the next slide. Flexibility. Flexibility is the name of the game here. Now, flexibility has real tax impacts and tax benefits. When you have a family trust structure, all of the profits that you're generating in your trading companies that are flowing up into the holding company, where normally profits would go to the shareholders and you declare them in your name as the owner of the shares. You now, by inserting this family trust structure, put on a different hat. You put on the hat of a trustee. You basically get to sit down, work out how much your business interests have earned in profits in a year, and using the flexibility of the family trust, you can decide who in your family group gets the profits from a tax perspective. Now, that means you look around, you sit down with your accountant in the lead up to the 30th of June for most taxpayers, and you look around at your family group, and you might have a non-working partner. You might be in the business earning a good salary or taking drawings up to $200,000 a year, say, if everything's going incredibly well. And that means that you've got a good problem in that you're paying a lot of personal tax. You're up at the 47% point already. Okay, but maybe you've got a non-working partner or a partner that works part-time. Using the family trust's flexibility, you might decide to take your company's profits and pay them as a distribution to a non-working partner or to some adult children that you're supporting, or even to your aging parents that you're supporting. This flexibility allows you to basically determine where these profits can go from a tax perspective. As with all of these things, you have to do this in consultation with your accountant, who can help you navigate some of the complications. But overall, it can be incredibly tax beneficial from day one. If you're a business that is operating profitably, you will be repaying your setup costs for these sort of structures very, very quickly.
And Tim, I might chime in.
There are huge asset protection benefits. Again, Damon's itching to talk to you about them. I think that we've got some slides later on from the legal perspective, but Damon, do feel free to jump in very briefly if you'd like to talk about asset protection.
Well, just on that point, I
think you might be on mute, Damon, or maybe I just can't hear you.
All right. Can anyone hear me? No. Oh, everybody can hear me except for Tim. All right. So I was just going to jump in quickly for, I'm not sure if Tim can hear me, but in essence, the asset protection side of things is more from the legal side. And that's really helpful because you're not actually the one that owns your company. It's the separate entity, which is the family trust that owns the company. So if you, for instance, went bankrupt, a trustee in bankruptcy would take the shares that you own in your companies away from you. But because the family trust own the shares, it means it's a separate entity, which means that you won't be able to have those shares taken away from you, which gives you that asset protection. And in the previous slide, there was also a mention of PPSR. And the PPSR is what's called the Personal Property Securities Act. And it shows that there's a license agreement between your holding company to your operations company. So if you were to create that dual structure, what's important is that you put all your main assets into the holding company, like if you own a factory in the holding company, if you own equipment, holding company, if you own software, holding company, and then you license it down to the operation company to be able to use. And the importance of that is that if anything ever happened to the operational company, then the holding company can claw back all those assets and they're all protected. But what's important is that you register a security interest against the operation company under the Personal Property Security Act. And the reason for that is that if a liquidator is ever appointed to your operation company, the PPSR is a legislative security which can defeat a liquidator. And if you don't have that license agreement and you don't have that registration, it is possible that a liquidator could turn a blind eye to an informal license. And therefore, if you don't know anything about PPSR, it's worthwhile having a look into it or look at the videos that we mentioned on YouTube talking about that structure and why you might have a license agreement plus a PPSR. So that's it. I'll pass it back over to Tim. I don't think he can actually hear me, but I'll see you later on in the slide.
That's us. Thanks very much, Damon, for what I'm assuming was an incredibly useful and informative bit on asset protection. We move quickly ahead. We're starting to think, if we're going through this life cycle of the business, we're now starting to think seriously about share capital. The standard setup that most people will do when they set up a company is 1 or 2 shares for $1. And for a company that wants to stay at that size where you're self-funding, that's absolutely fine. The issue then comes when you're looking to raise capital and issue new shares. If you have only set up with 1 share for $1, if you would like to issue more shares, you're very quickly giving away 50% of the company. So if you already have 1 share on issue for $1, you issue another share, that's half your company. That's not terminal. You can do what's called a share split, and you can split that share into 100, 100,000, or whatever you want, basically, shares. But it's easier if you're already thinking when you're setting up the company that you're going to be raising capital externally. Do it from day one. Set up your company with 10,000 or 100,000 shares at 1 cent per share. There's no impact from a tax perspective, just makes things easier when you're looking to issue new shares. Thanks, Connor. You might have heard this phrase thrown around, the cap table. What does it mean? Is it incredibly complicated? No, it's typically an Excel spreadsheet that doesn't look terribly impressive. But what it does show is not only what you have at the moment, not just your shareholders in one column, you have new columns to anticipate and calculate what's the effect of my next raise. It's a really great way of being able to demonstrate to your shareholders what does the future look like. Now, for those of you that haven't done this before, there's a terrifying moment that happens when you are looking to issue new shares and raise more money, this idea of dilution. Now, anytime you're looking to raise more money and issue your more shares, well, the initial shareholders or the early shareholders get diluted, by which we mean they reduce their overall share in the company. Now, why on earth would you want this? Of course, the idea is as you're raising money, the size of the pie increases. Now, your sliver your share of the pie might be smaller, but if it's a bigger pie, everyone wins. But the idea of a cap table, and there's plenty of templates out there, a lot of the big VC models will put them out to try and tempt you in. It demonstrates to you. It allows you to say, well, if I'm going to raise $5 million at the next raise, what's going to happen to my existing shareholders? They might go from 42% to 38%. It's just a good way of being upfront with your shareholders. Of course, experienced and sophisticated investors will expect this, but the people that might not, potentially your angel investors, your friends and family, might not be familiar with it. Having a cap table and being reasonably open with it and explaining and understanding yourself, your financial model, will basically make that process a lot smoother. This whole process of capital raising, it is something that I would never, ever recommend you do on your own, for the simple reason that when it goes wrong, it goes spectacularly wrong. It is a bit of an investment, of course, up front to make sure that you've got your I's dotted and T's crossed, but it absolutely will repay itself. So when you're looking to raise capital, and there's a slide coming up about those sort of records that we keep, have your lawyer across it. They've done this 100 times before. They know what to look out for, and you invariably haven't yourself. Please do invest in making sure that you get that all done correctly. Connor, if we have a look at that next slide. What are the sort of records? There's a billion of them. It can be quite complicated. It's obviously a convoluted legal process. A lot of things happen. Shares get issued. You'll invariably sign a shareholders agreement. There'll be resolutions, there'll be minutes, consent forms. There is a lot to take care of. It's not impossible, but of course, someone that's experienced, an experienced lawyer, will have seen this before and knows what to look out for. At the same time, you might be doing some other things, that phrase ESOP, which some of you will be familiar with. It's basically, it can describe any number of different share or option schemes whereby you're giving your employees the opportunity to participate in the company and become shareholders. A lot of the times when you're capital raising, it's something that you consider at the same time. A lot of people are sort of worried. A lot of company founders are worried that maybe their ESOP is too big. They're giving away too much of their shares, and they're surprised when venture capitalist firms actually want you to have an ESOP in place because they want to see that your employees are invested in the long term. So just make sure you've got, again, all of your documents sorted out. Thanks, Connor. ESIC, this is a favorite topic of mine. We always look for silver bullets when it comes to tax effectiveness and tax minimization, and there aren't many silver bullets out there. And generally, there's limited things you can do to reduce your tax. ESIC is one of those rare occasions where it's really a win-win. It's not for you as the founder. It's for the next stage of people that you've got coming on board, particularly angel investors or people that you know of in the community that have maybe got a bit of cash to burn in investing in your company. It allows these investors to receive a tax offset, which can drastically reduce your tax bill. It's a non-refundable carried forward offset, which basically means it won't give you a tax refund, but if you're the sort of investor that has a tax bill to pay, it can bring it down significantly. And for sophisticated investors, that can be as high as $200,000 a year. Even more generously, capital gains tax-free. If you own these shares in a qualifying ESIC company, you own them between 1 year and 10 years. When you sell those shares, fingers crossed you've made a big profit, fantastic, you won't pay tax on that profit. It really is an incredibly generous scheme that can be really useful for that first occasion where you're going out to the market to receive external funding. Sort of softens the blow up front and gives them something to look forward to when you sell. You have to obviously meet some qualification criteria for that, which your accountant and certainly us at LawPath can help you qualify for. You have to be an innovative company. There's a few ways of getting to that stage. Thanks, Connor. I think we skipped over ESOP. We already briefly touched on it. It's a fantastic way, low cash cost, because you're not paying your employees this ESOP benefit in cash, but it's a way of giving them a benefit, and it's a way of aligning interests. That's really the best way of looking at it. If you have an employee who has shares in your company, or options to buy shares in your company, they are more inclined to work their damnedest to build your company and make it profitable. It makes sense. We're all creatures of self-interest to an extent. We all like to be involved, and it's a way of basically making sure that particularly your senior hires and your really experienced people, perhaps in your startup or in your new business, you don't have the cash to pay them as much as the market would dictate. Well, this is a nice way of building that gap. Typically, we see 8, 10%, as high as 15% of your company will be set aside for this ESOP. It doesn't mean you issue it at day one. There's typically a vesting period. Now, a vesting period generally means that you won't get all of your benefits up front. It'll be eked out to you over time. So typically 4 years is a very common vesting period that we see. The startup concession ESS is a type of ESOP. There are many types of ESOP. Which one's right for you? It depends. The startup concession is a particularly generous one for companies under 10 years old because it's not only defers tax, as many of the schemes do, but it pushes you into capital gains tax territory rather than income tax. We like capital gains tax more because if you hold shares for more than 12 months, you get a 50% discount. So particularly good scheme for new companies. Thank you, Connor. Budgeting. It's not the most exciting process. If anyone has a personal budget, you're doing better than me. I just get the credit card out and spend what I need to. But it doesn't work in business to operate like that. In business, you really, really need to have your strategy in place. It can be big picture, but really try and drill down. Once you've got your big picture strategy, how is this going to affect the bottom line? How is it going to affect my cash? You generally will have a certain level of cash that you will treat as your runway before you need to take off. So for a new business, it's very important to make sure that you can get your business to this takeoff point, this break-even point where the business is generating money. But to get there, you'll use up your runway of cash that you've already got. So you really need to be able to point to things, basically, how is this business going to get to the point where it's going to be self-sustaining? How much money do we have and how much do we really need? It's something that I recommend you do multiple drafts of and never think of it as complete. Your budget should be updated as you grow because you'll never get it right day one. It's impossible. There's just too many unknowns. I would say as a general rule, have a few different versions, have a baseline version, a what if my assumptions aren't as good version, and a what if everything's going well version, and assume that it's going to be the bad version. Because often early stages of business are complicated and a lot of businesses will fail in the first 2 years. So be pessimistic. That's my primary bit of tip for you when you're doing your budget. Again, if you can, spend a bit of time and invest it with an accountant. If nothing else, just to have them sense check your numbers. Invariably, good accountants that work with startups have seen every budget under the sun, and we can push you in the right direction, even if you don't want to go full hog and have us build it for you. Thanks, Connor. We've already talked to death about budgeting. It's not too exciting. Do remember your tax obligations, of course. That is something that can get left out. GST, not terribly important. Someone asked early on, what about some payroll compliance? Well, the most important thing with payroll compliance from a tax perspective is that at a very early stage of operations, you will have to be withholding tax from your employees and paying that to the ATO. So for most people hiring employees, the burden of tax compliance isn't on the employee themselves, it's on you. So from an employer perspective, you need to make sure that you've got your employees' tax file numbers. Once you've got them into a compliance software, a Xero, an MYOB, a QuickBooks, these software packages will tell you how much to withhold. So that's a nice job, easy job taken care of. But you must then remit that to the ATO, pay that to the ATO, typically once a quarter for very small businesses. But sooner than you think, you'll pop into the once a month category. So engage your accountant early, make sure that you've got yourself ticked off. Thanks, Connor. All right, now we're cooking with gas. You've been running for a little while. You've got your accountant, hopefully LawPath Tax and Advisory, on track. You've been compliant. You've been building your business. What's the next step? Maybe you're looking at splitting into your new companies. You might have expanded to the point where you're doing very different, disparate things within your one company. It might be time to separate them out. There might be opportunities to move intellectual property into a different structure. There might be a need to ring fence from a legal asset protection purpose. We can split these things into new companies. Nothing is set in stone, as I mentioned with structure. It couldn't be time to look again at structures. In particular, maybe if you don't already have a holding company, if you're not already holding things through a family trust, now's the time. How's your software working? Are you running tracking? Are you doing projects? If you're just doing a basic chart of accounts, it'll only take you so far. If you need visibility about how your business is going on a real micro level, you might need to get more complicated. And how are you going to fund this expansion? It's a rare company indeed that can fund expansion through profits. Typically, you'll be looking to raise money. Whether that is debt or equity is an important consideration. It'll depend on the market for fundraising. It'll depend on interest rates. It'll depend on any number of things. Now, there are, of course, lots of non-tax things to cover off, but I'll leave that to someone else. Are you looking at R&D tax incentives or export market? Do you need to really build out your finance team, which I think is on the next slide? Probably a good time to talk about finance team. What does that mean? For a startup, the finance team is often you. It's often just you sitting down with your software and muddling through it. I would encourage you to seek a bit of external help, because it's not the best time for you when you're building a business to also worry about running the finance team. Once you get to a size that you can afford it, you start with a bookkeeper perhaps. You get an accountant on board. It becomes more complicated. You might need a CFO, the value of their advice. Maybe a fractional CFO. There's plenty of people out there that can support you on a part-time basis, but it does take some looking at. Don't think that you have to do it all yourself. Thank you, Connor. Skip right over the finance function, but there are some important things when you have a look at the slides. Just do make sure the most important thing is keep everything up to date. Make sure your accountants are on board, lodging your stuff. The worst thing that I can say is don't leave it. Don't bury your head in the sand for 2 years and think that you'll be able to dig your way out. Invariably, the tax debt that has worked its way up, even if you're not profitable, you still have to pay GST. It can sink businesses and does. So just stay on track and on top of things. Thanks, Connor. Yeah, look, the bigger you get, the bigger the tax problems get. There's some annoying additional taxes that will pop up as you scale. Fringe benefits tax. Please, before giving a non-cash benefit like paying health insurance or buying lots of gifts for your employees, please do talk to your accountant before you do that. Fringe benefits tax is punitive, by which we mean it will tax non-cash benefits at a higher rate than cash benefits for many employees. So do bear that in mind. There are state level taxes that will pop up. Whichever state or territory you're in Australia will have its own payroll tax. You'll get more frequent with your obligations to the ATO. There could be capital gains tax to pay as you're restructuring and building. And the ever-present issue of director loans, Div 7A, for those of you that talk to accountants a lot, will rear its ugly head. Please do get advice before you take loans from your company. Loans to your company, less problematic. Loans from your company, it's going to raise some red flags. So let us help you deal with them. Thanks, Connor. Look, that's it from the tax side of things. And as Connor mentioned, I do have to duck off in a minute. So before I hand over to Damon on the legal side, on the Q&A function, if you've got any quick questions, Peter has asked a question there on, does the ATO need to make a ruling on your ESIC status? No, you can seek a private ruling, or you can seek the Commissioner's discretion to declare you an ESIC, but you can actually self-declare it. There is a way to do it. There's a 100 points test, which is a nice and easy, surefire way of doing it. There's also should I say more generous? There's a way of self-certifying based on a principles-based test as well, Peter. And we do assist some of our clients with building that self-assessment case. Or, of course, we can help you with an application to the ATO. But you have two options there. Any other questions from a tax perspective before Damon gets let loose? We've had a question, holding company, can it be a private company? Invariably, yes, a holding company will be called what we call a proprietary limited, a PTY limited company. That's typically what a holding company would be. Fantastic. Look, we'll keep obviously the text line open here on the text Q&A. If more tax questions come in, I'll pop them in the chat. Over to you, Damon.
Great, thank you. Hello, everybody. So we are primarily going to talk about some of the more recent employment law changes, because that's important for every business. But first of all, we'll just look at some of the contracts. It's amazed us that the main elements of a contract oftentimes are missed. So Connor, if you can just move on to the next slide. So let's talk about your business contracts generally. A lot of people skip over the termination clauses, the clauses that deal with the duration of the term or automatic renewals, things like that. So one of the things that, yeah, it's just bizarre that people don't look at these clauses very carefully. So the first thing is, if you're going to have a contract, it's generally not going to be indefinite. And if it is indefinite, then you have to have a very clear termination clause. So what that means is that if you say the contract is continuing until terminated, then you're going to need a clause that deals with the termination. And there's normally 3 ways to terminate a contract. And when you look at the termination clause, there's normally 3 things. One is termination for convenience. So that means that either party can issue a notice to the other party saying, I hereby terminate the agreement without reason, without cause, on 30 days notice, 60 days notice, 90 days notice, whatever it might be. And when you're setting that period of time, you want to consider, well, are you okay for your client to be able to just simply terminate the contract on 30 days notice? Or do you have third-party suppliers who are also working on this contract, and do they also have 30-day terms? So it might be that you need 60 days before someone terminates the contract. You also look at if someone breaches the contract. So that's a next clause that you would have in the termination provision, which is if it's not by notice, but it's by cause. Normally you would say, if someone is in substantial breach of a material term of the contract, then you will first give written notice to them identifying what the defect is, what is in breach, and give them 14 days or 30 days to rectify that breach. And then if they don't rectify that breach, then the party can terminate. Now, without those clauses, there's no right to actually terminate at all. And so you need to be able to have the right to terminate in case someone doesn't pay you or in case someone's not fulfilling their obligations under the contract. Now, a lot of people will put in an automatic renewal clause, and those automatic renewal clauses say something along the lines of this contract is for a 12-month period, and at the end of the 12-month period, so long as it hasn't been terminated by either party, it automatically renews. Now, under Australian automatic renewal clauses can be seen as an unfair contract term. And an unfair contract term occurs where it's a standardized contract, like an online click to accept agreement, which just automatically renews without giving notice to the other side. So if you do have an automatic renewal clause, it's worthwhile reviewing it because the ACCC has been prosecuting the big guys for having automatic renewal clauses without giving notice prior to the renewal or not bringing it to the client's attention. And so when you do have the automatic renewal and you have an automatic debit, it normally means that the debits keep on coming out month to month. So it's important that you make sure someone's aware of that clause. And if they are aware of that clause, make sure that they are given notice prior to the renewal date, so that you're not found to be falling foul to the ACL, the Australian Consumer Law, and having an unfair contract term. And so those are the main things that we look at when we look at the contracts. And the only reason why we're identifying this now is that we found that a lot of people are missing the essential termination clause. Next slide, Connor. Now, what we want to do also is look at, is your business protected? So if a deal goes bad, do you have sufficient clauses to protect you? The purpose of a contract is to try to minimize disputes. When you have a contract, it's an agreement, and an agreement is an offer, an acceptance, a meeting of the minds, and consideration. Offer meaning someone's clearly made an offer. Acceptance, someone's accepted that offer. Meeting the minds means that it's not vague, ambiguous, and uncertain, meaning that the people who are entering into the agreement both mutually understand what the agreement is. And so if you don't have the essential terms in an agreement, it can be found that an agreement's not legally binding because it fails that essential element of having a contract that's sufficiently clear. So when people have like a handshake deal, a lot of times a handshake deal can fall apart because the essential elements are not there. So for instance, if you do a handshake deal to buy a property, well, it's not legally binding because under the conveyancing legislation, it says that the sale of land has to be in writing. If you do a handshake deal to buy goods off of somebody, and then they don't deliver the goods, you can say, well, I entered into the agreement, they promised the goods, but you didn't say when the goods would be delivered, you didn't say how many, you didn't say what the price was going to be, and therefore the contract will be vague, ambiguous, uncertain, and won't be legally enforceable. So that's why we want to make sure that we have a detailed contract in place to help your business grow. And if there is a dispute, you're able to resolve the dispute. And so it's really important to consider whether you want a dispute resolution clause and or an arbitration clause. So if you're doing business internationally, for instance, let's say you're signing up to a contract with a customer that's in the US and you're delivering services to the US company. And let's say, for instance, contract's going well and then they've stopped paying you. And when they've stopped paying you, you want to sue them. So you have a clause in your contract that says you're allowed to sue them in Melbourne. So you go and you sue them in the courts in Melbourne. They don't show up. You get judgment against them in Melbourne. Happy days. You now have a judgment against them. The problem is that you can't enforce the judgment because they don't have any assets in Australia. So the only way now is to go to New York, for instance, wherever the customer is based, and start the case all over again and run a brand new case because we don't have the mutual recognition of judgments between Australia and the United States. So just because you get an Australian judgment, it's not really worth the piece of paper it's written on in the United States. So oftentimes when we do business internationally, we'll have what's called an arbitration clause. And the United Nations came out with an international convention called the New York Convention on the Foreign Recognition and Enforcement of Arbitration or Arbitral Awards, 1958. And in short, what that says is that anyone that's in a commercial arrangement can reach an agreement to exclude court from resolving any disputes, and you're barred from entering the court, and you're forced to go to arbitration. And so what is arbitration? Arbitration is basically you get a third party to make a decision, and that decision's binding. So if you enter into contract with someone from the United States and you say the applicable law is Australian law or Victorian law, and the place to resolve it is Melbourne by way of arbitration, and the other side agrees to that, and then you have a dispute because they haven't paid you, you then go to arbitration, not court, and you get an arbitration decision, you can now recognize that decision in 151 countries around the world. You can effectively go into a New York court saying, here's a decision from Melbourne, and under the New York Convention, I want it recognized and stamped as if it was a judgment for New York, and the courts will go and stamp it. Because under the international treaties, the countries have agreed to allow parties to fulfill their wishes, which is to exclude courts, except for the enforcement of decisions, exclude courts, force people to go to arbitration if that's what they want, and then to be able to force an arbitration decision. So that's just something to consider if you're doing international business, because Australian law and resolving a dispute in Australia might be of no value to you if you're doing business internationally. The next one to look at is whether you want warranties on the other side. So if you have Australian law, then you have automatic warranties. Whenever you're providing services, whenever you're buying goods or selling goods, you have the warranty under the Australian consumer law that the services you deliver will be fit for purpose, will be done with reasonable care and skill, will be completed within a reasonable period of time. And if you're selling goods, then they're going to be of merchantable quality, they're going to match the description, things like that. So you don't always have to have these warranties in a contract unless you want something more, but those warranties will automatically be implied and you're not allowed to exclude them. Now, you can potentially limit the liability to breaching those warranties, but you want to consider whether you want these kind of warranties set out in the contract, because if someone breaches a warranty, that's expressed in the contract, it then gives you the opportunity to terminate the contract. So for instance, if you hire a software developer and they promise to develop a minimum viable product for you within 6 months, and it's now 9 months and you're not getting anywhere and they're demanding more money, well, you can say, well, they haven't delivered the services within a reasonable period of time in breach of the Australian consumer law. If you have it written in the contract, you can say that's a breach of the warranty under the contract, and it gives you a right to terminate the contract. And if you terminate the contract, then the damages that you can recover is the loss and damage sustained as a result of the breach, which might be if they delivered you half the product that's incapable of being completed, then it might be all your money back. So consider these kind of warranties in your contract. A lot of people will draft contracts that only say that the service provider has to provide obligations, but it doesn't say the other side has to do anything other than pay you. But oftentimes you're providing a service, you need the other side to give you certain approvals, give you certain documents, review certain things with you, give you comments or direction, things like that, or instructions. And if you don't have a positive obligation on them and you give them something, and they don't get back to you, then you're sitting around waiting to finish your services, but you can't until they get back to you. So if you do need input from your customer, then you want to put in a positive obligation in the contract saying the client's required to provide written approval, direction, documents within a reasonable period of time when requested, or within 3 business days from the written request, so long as it's reasonable, something like that. A couple other things to look at is intellectual property. So it's important to know that if you hire an employee, anything that employee does while they're working for your business is owned by you. Any of the intellectual property created is owned by you. But if you hire a contractor and you don't have a written contract, anything that the contractor does is owned by them. there's probably an implied license that you're allowed to use it because you've paid for the services for it to be done. But when it comes time for you to do your capital raise, and when it comes time that someone's doing due diligence on your business and is looking to see whether you own the intellectual property and you don't have a contract with all your contractors, the investor will either, one, not invest in your business because you can't prove you own the actual software or technology or processes or systems or whatever, or two, they'll make you as the founder give a warranty that there is no dispute in relation to the intellectual property. And if there ever is in the future, then you will lose your shares or you'll have to pay damages to the investor. So if you don't have an intellectual property clause in those kind of contracts, it's really important you do so. And if you've hired contractors in the past and you didn't have an agreement in place, you can do what's called an IP assignment deed, where it's basically saying, oops, I forgot to give you a contract. Remember when I hired you to make the logo for me? Can you please sign this deed of assignment, assigning over that logo to me retrospectively because I forgot, and get them to sign off on a document going backwards. Now, the reason why it's a deed as opposed to an agreement is an agreement, as I mentioned, has four elements: as offer, acceptance, meeting of the minds, and consideration. Consideration is I'm giving up something for receiving something. So I'm giving up my time to provide you legal services in exchange for you paying me for money. Now, in the case of a deed, you don't have consideration. So for instance, you hired someone to create your logo in the past, they've created it, and then you've paid them for it, and now you forgot and you say, oh, can you sign this document? Well, there's no benefit for them signing this document because they've already done the service, they've already been paid for it. So why are they going to sign this document you just given them? Which means there's no consideration. But to get around that, you do it as a deed. And if you do it as a deed, you don't need consideration. But when you have a deed is signed differently. It has to be signed, sealed, and delivered. So a lot of times when you have an agreement, an individual might just sign their name. But when you have a deed, it has to be signed by them and witnessed. So there's a couple extra elements for a deed to be properly executed to be enforceable. Next slide, please, Connor. Now, when we look at the rights and obligations, I already talked about having obligations on both sides. It's not just you delivering the services, it's not just you delivering the goods, or it's not just you receiving the goods or receiving the services. You want obligations on both sides. So let's say you're selling goods and you're delivering it to a particular address. If someone isn't at home, you have to do a redelivery of that good because they asked for a signature, but they're not home when you're delivering it. So you probably want a redelivery fee to be charged in the event that they're not available. Or if they give you the wrong address, you want a fee in your contract that says if they provide the incorrect address, then they have to pay for a redelivery fee. If cancellation policy is something else where you want an obligation, they've read, they understand the terms and conditions of your agreement. There's no change of mind refunds, but there is a refund if it's defective or incomplete. So these are both obligations on both sides. They've read the terms, they understand that there is no change of mind refund, but if they can prove that it's defective or if they can prove that it's faulty in some way, then there is a right to a refund. So those are just some things to consider. I have a bunch of cases where people have always thought, you know, I'm entering into the contract with the bank. The bank's never going to go insolvent, so I won't even worry about looking at the insolvency clauses. And then during the GFC or during COVID, a credit union goes under and they never actually read the contract in that way, thinking that would ever happen. So when you read a contract, you got to look at it, try to make sure it's mutual going both ways so that if something out of the ordinary does happen, you're protected. And then when you set out obligations, you know, as I mentioned, if you say to the client, you have to give me documents within a reasonable period of time. Well, what does reasonable period of time means? If you want to actually have a dispute on a reasonable period of time, you got to go to court and the judge will look into all the facts, matters, and circumstances and determine what is a reasonable period of time in those circumstances when comparing it to what other reasonable people would consider to be a reasonable period of time. So you want to be specific. And that's why a lot of times you'll see service level agreements where it says, if it's a high priority, low priority, mid priority, it's 2 hours, 4 hours, 8 hours response time. They define what high level is, they define what mid level is, they define what low level priorities are. It's specific so that you don't have to go to court to make a decision on this. So if you are going to set out an obligation for someone, whether it's you or them, you want to be as specific as you can. And you want to be specific so that you understand what has to be done, when it has to be done, and how do you know that it's actually completed and fulfilled. And if you don't have those specific requirements, someone might say, well, I did it. And you said, well, no, you haven't. Well, what is the thing that they actually have to do? And do you have a measurable test to determine whether it's actually being completed? And if you don't have the measurable test to determine whether someone's being completed, then oftentimes you'll say, we will deliver this to the client's reasonable satisfaction. And then it's the client that has to decide whether it is or isn't, and it takes the power away from you. So instead you say, we will deliver it based on our reasonable decision that it's being completed. So these are just things to consider when you're drafting a contract and looking at the terms of the contract. Next slide. Now, some of the employment changes are fairly important. Some of them probably won't apply to small startups. So we'll just move on to the next slide and we'll talk about those. So flexible work arrangements has been around for quite a while. Something that everybody needs to know is that if it used to be that only in certain circumstances does an employee have a right to ask for flexible work arrangements. A lot of times it was like a care situation or a parent. So for instance, that a parent is the only care for their child. They need to come into work at 10 because they have to drop off their children from school, and they have to leave at 3 because they have to collect their child from school, but they will start work earlier at 7 or they'll finish later at 6. And so they're looking for a flexible arrangement to be able to come in a little bit later and leave a little bit earlier on Tuesdays or something like that. They've now expanded that to not just carers, to anybody. So anyone that's employed in your business has a right, except for casuals, to request for a flexible work arrangement. And that can mean anything. That can be working from home, that could be working remotely on certain days, that could be taking an extended period of time to go back to see their parents and then work remotely for a week. It could be anything like that. And you have a positive obligation now to consider it. You can't just reject it, you have to consider it. And to refuse it, it has to be on reasonable business grounds. So you would have to give a written response if you are going to refuse it, explaining why you are refusing it, and then outlining what those reasonable business grounds are as to why you're not going to refuse or why you are going to refuse it. So for instance, if you have a big sales team, that sales team has been proven based on research to be more productive, working together as a team, celebrating their wins each day, then you might have a reasonable business expectation that the sales team has to work from work, because statistically and based on past performance, it's proven that sales professionals work better as a team as opposed from working at home. That might be sufficient grounds to refuse someone in the sales team from working remotely permanently, for instance, but it might not be sufficient to a request from a worker to work from home 1 day a week, or to work from home or from showing up late and leaving early on certain days to collect their child, for instance. So that's the first one, is flexible work arrangements. Move on to the next one. There's a prohibition now on fixed term contracts. So it used to be that people would go through a recruiter to hire someone to put them on a contract. So employers looking for someone, they go to a recruiter, they ask the recruiter to hire this person for them on a 1-year contract, and then they place that person into the company. And then at the end of the year, the company goes and says, okay, renew the contract, and the recruiter then renews the contract, puts them in again, and then they just keep on doing that for 10 years. It's been found that oftentimes they're not actually a fixed term contract. They're not for a specific project. They're not for a specific client. There's no legitimate reason as to why the person is on a fixed term contract. And so they put a stop to it, where they've effectively said, if you hire someone on a fixed term contract, you might be able to do it for up to 2 years, but after those 2 years, they'll be deemed a permanent. And even if you give them a fixed term contract that says it's fixed term, they're more likely than not to be deemed a permanent employee if it's gone on for more than 2 years. Now, there are certain exceptions, like if it's a project based or if it's client based or something like that. So for instance, if you have a client that requires this person, you put them into that client's work for that specific project, then it might be okay to have a fixed term contract that's more than 2 years, but but as a rule of thumb, fixed term contracts more than 2 years is no longer, it's now prohibited. Next slide. This is the most significant one that's just changed recently, last year, and it came into place, I think, in November. I think possibly November 1st last year. And essentially, the law used to be that if you gave a contractor agreement, and that contractor sent you an invoice every month, then if it looks like a contractor and acts like a contractor, it's a contractor. But there were circumstances where a contractor could say, well, yes, I have been invoicing them, but I'm really an employee. This is just all a sham. I'm an employee, and they asked me to sign a contractor's agreement, which I agreed to do, but I've now been there for many years, and I'm really an employee, and I want all my employment rights. And so back then, the courts would look at it, and they would look at all the factors. The first paramount thing that they would look at is, what does the contract say? And if the contract said it was a contractor's agreement and it said that the contractor was invoicing you, then highly likely that the contractor is a contractor. But they also would look into several different multi-factor tests, like, do you have certain control over them? Are they required to comply with your policies? Are they able to choose their own hours? Are they using their own tools, or are you giving them their laptop and their computer? Are they allowed to delegate their work to other people? Are you making them wear your company uniform? And the uniform one was quite important because they say all contractors must be able to have their own enterprise, meaning they must be able to run their own business, which enables them to be able to subcontract the work, to find other work elsewhere, choose their hours, and so on. And so there were two high court decisions in 2022, and both of those decisions basically said, yep, we still look at the contract first, we look at that as a paramount factor, and then we consider the other factors in determining what kind of control the employer has over the contractor. And then we might deviate from the contract if there is a lot of control. And this is why Uber and Fedora and ASAP and all these different companies were getting found to be falling foul. Uber has always been successful in defending it, but Fedora, I think, had to run away from the country because they found that all their contractors were deemed employees. So there's some really big cases that came down, and the government didn't like the high court's decision. The government thought, that's not right. If someone's forced, or if someone signs a contractor's agreement and it looks like a contractor, but they actually are employee, having a look at all these factors and just going back to the employer and saying, oh, you can just rely on the contract, they didn't think that was fair. So the legislature has reversed the high court decisions, and they inserted a new section into the Fair Work Act, which goes against those decisions. And it specifically references those two high court decisions, saying we're inserting this clause because of these two high court decisions. And now it is, we really don't care what contract you sign, we look at the factors. So we look at whether you have ultimate control over them, whether they can control their own hours, whether they can delegate their work, whether they can subcontract the work. And if they can't subcontract the work, if they don't choose their own hours, if they have to wear your uniforms, if they're using your tools, if they're following your policies, if you look at all these factors and they actually are an employee, then we don't care about what the contract says, and it's no longer of paramount importance. Which means that every time you hire a contractor now, you're falling into a risk that it could be seen that they are an employee. And if any of those contractors were to bring a claim against your business, then you could fall foul to the fact that you've hired them as a contractor when you should have hired them as an employee. You haven't been paying minimum wage or award rates. You haven't been paying them possibly allowances, penalty rates, things like that. And you haven't been paying them annual leave, sick leave, public holiday pay, and they can make orders backdating all those entitlements as a result of you putting them on as a contractor when you should have hired them as an employee. So that's really, really significant and really important if you're ever going to enter into a contractor's agreement. Next slide. The right to disconnect, you would have seen this on the news. I'll just touch lightly upon it. Basically, an employee doesn't have to respond to your text messages or emails after hours unless there is exceptional circumstances that, like some kind of urgency that requires them. But otherwise, they don't have to. You can't force them to. End of story. That's essentially now the law. And if you do try to enforce it, then it's a breach of the law. It possibly could be seen as bullying and harassment as well, because it's an unreasonable demand, which is unlawful, which is against any kind of company policy that's allowed to be in place if you try to get them to respond to you after hours or on weekends. And if you do try to take action against them, not only might it be bullying and harassment, it could also be seen as what's called a general protection claim, which is someone has a workplace right. They've exercised the workplace right as a result of exercising the workplace right not to respond. Adverse action has been taken against them because they get fired or they get dismissed or they get demoted or they get punished or get a warning as a result of not responding. Then it can open up another realm of compensation that the employee can bring an application against your business for compensation for breach of general protection laws or breach of this law. Next slide. Same job, same pay. This is more bigger enterprise, but essentially where you have employees working in one role and then you hire a contractor in another role and you're offering the employees better rights than what you're offering the contractor. Well, they say that there is a requirement that if you're hiring a contractor through a labor hire agency, then that contractor should have the same rights and the same pay as the employees. And next slide. Unfair contract terms. So it used to be that if you have a clause in your contractor agreement that was unfair and you're the employer and you say, well, you terminated without notice because we just decided to do it, the contractor can bring a claim to the Fair Work Commission now and say that that clause is unfair. And if it's found that that clause is unfair or unlawful, then you aren't allowed to enforce that clause. So it just gives more powers to the contractor to seek orders from the Fair Work Commission fairly urgently to have certain clauses of your agreement struck out and unenforceable. And next slide. Okay, so that's it. So if you have any questions, please drop them in now. I'm not sure if I'm going to be able to hear Connor.
Can you hear me?
Yes, I can. Great.
Yeah. It was as soon as Tim left, I was able to hear you again.
Okay, great.
On there,
So I'll pass it back over to Connor. Start putting your questions in the Q&A, and then I'll be back in 2 minutes.
Awesome. Thanks, Damon. I'm conscious of time. I do want to get to the Q&A quickly, so I'm going to whiz through how LawPath can help. So I'll just say early on, if you do want to understand a bit more about the inclusions and exclusions of these services and or would like a platform demo just to see what it looks like to either build a contract or book a consultation or a litany of the other services we provide, please just type yes in the chat box now or just reach out to me directly. And for those who jumped in maybe later, we'll be sending out the slides and the link as well for the video, hopefully later this afternoon. So just bear with me for that. But firstly, just a quick overview of our most popular legal plans. That's the essentials and legal advice. Literally what it says there on the tin. So we provide over 500 fully customizable legal documents. They're really easy to use. They're a mix of contracts, agreements, and other legal forms. But our most popular service there being the legal advice. So combines the contracts, but now you have unlimited 30-minute consultations with our lawyers, as well as unlimited on-call contract reviews. And as I mentioned at the start, if you do require anything really bespoke, really specific, really high level, you do and can get discounted fixed price quotes on contract drafting or different legal issues like trademarking and different tax things, which you'll see shortly. We have a host of AI tools in there as well, which you guys can have a look at. Maybe some of you are already on the essentials. If you don't have an account with us, you can actually just set up a free account with us and use one document and get a general gist of how it looks to use the platform. Then we have the accounting and tax compliance services, part of LawPath Tax and Advisory. So same concept as the legal advice, unlimited 30-minute consultations with our senior chartered accountants. And you can combine that with the tax compliance. That doesn't include the consultations, albeit two very specific ones, including an initial consultation and a special fiscal year consultation, just to go through, how your business basically performed either side of the financial year, and just make recommendations to performance, to improve performance in the next financial year. But it's all that hands-on work stuff. So your annual quarterly BAS statements, annual financial statements, and annual business tax return. And last but not least, you can combine all of these. So we have all the prices up there on our website, whether it's for like an annual discounted amount or quarterly options. But if you do bundle all three together, you get an immediate 40% discount on that subscription. And finally, as a special for everyone on the webinar today, you can actually apply a 20% discount on the quarterly option for the legal advice plan.